Survives the plea.
Yeah, I get it. I'm just looking real quick. Michael Sarant. This is Miss Malfino.
I mean, Judge, I'm sorry, I'm still.
That's okay. I just want to make sure you you heard.
I think sorry from.
Good morning, sir. You Michael Eugene Sarant.
Yes.
And will your client waive the formal reading of the indictment?
So worried.
Mr. Sarant, in cause number 25, DCCR 1691, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle.
And just like that, we're entering one of the fastest but most important moments in any criminal case, the guilty plea. Don't let the speed fool you. Every single yes, ma'am, you're about to hear carries massive legal consequences. Once a defendant voluntarily pleads guilty, they're giving up some of their strongest rights, including, in many cases, the right to challenge the outcome later. The question is, does he fully understand everything he's agreeing to?
From October 16th of 2025, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimball?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a 3-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Swan is not competent?
Yes, ma'am.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the
Interesting move by the judge here. She finds him guilty, but she's not sentencing him yet. That's because she wants a pre-sentence investigation first. Think of it as a courtroom background check. The probation department digs into the defendant's life, employment, family situation, criminal history, and future prospects before the judge decides his fate. It's a reminder that sentencing isn't just about punishment, it's also about risk assessment and rehabilitation.
probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation to start that process, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
All right, thank you.
Brian Snipes.
Bye. Good. Yes.
Good morning, sir. Are you Brian Snipes? And Mr. Snipes, in clause number 24, DCCR 2174, you're charged with the state jail felony offense of theft of mail with identifying information from February 2nd of 2024. Your indictment alleges that you were previously convicted of burglary of a habitation, a second-degree felony, February 18th of 2014. Okay, so it looks like two.
It looks like they're not sequential.
They're not.
Those priors. However, Judge, I do have in my possession a federal judgment that I intend on filing a notice of enhancement for the purposes of the record. It's a.
What's the date of the final conviction?
It's been a while since I looked at it.
February 18th of 2014 is the possession and the burglary, both second degrees.
February 18, 2024.
2014.
2014. Oh, 2014. Okay.
Yeah, Judge, I have a.
What's the date of that one? I'm sorry.
It's this one's from 2016. It's a federal possession and distribution of meth, along with the gun charge the defendant received a 93-month sentence on. My plan is to file a notice of enhancement, including that federal judgment, to get him to the 20 punishment.
Yeah, you'd have to see. I'm not sure if the 2014 conviction was final by the 2016 date, whether there was an appeal or mandate, something like that. So I would admonish him on a second, then, but he, in any case, he wants a trial.
So now things get risky. Prosecutors are discussing prior convictions and something called sentence enhancements. Translation. Old convictions can dramatically increase the amount of prison time someone faces. And here's the million-dollar question. Is turning down a 10-year offer a bold move or a dangerous gamble?
So I do want to make sure you understand, Mr. Snipes, that if those, the felony conviction, that I've read, those two, and the one that Mr. Coleman has, that he's going to file a notice to enhance. If those are actually sequential, so one was final before the other one was convicted, that means that your punishment would be enhanced to that of a second-degree felony, which is a minimum of 2 years up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Kimler that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, and what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
This is one of those moments courtroom watchers love to debate. The defendant just rejected a plea bargain and demanded a trial. Some viewers will call it confidence. Others will call it rolling the dice. Remember, plea deals are essentially negotiations, certainty today versus uncertainty tomorrow. What would you choose if years of your life were on the line?
All right, we'll get it set on the trial docket. Mr. Kimler will begin preparation for trial. Stay in touch with him and he'll let you know when you need to be back ready for trial.
Just for clarity purposes, I think in order that 10-year offer to be valid, those would have to be sequenced. I don't
Yes.
think one of them would get him to a third since they're not a 3G offense, so.
It's either a state jail or
Either
a
state
second.
jail or second. In the
Yes.
event that those aren't sequenced, then I don't want him to forfeit the opportunity. to
No,
go-
if there's some issue with the sequence, no, if there's some issue with it, that's why, yeah, I didn't,
I would agree to stay with.
Because they may
Of
come back
course.
with an offer in the state jail.
Sure.
So,
Yeah.
all
that
right.
make, yes.
You can go.
Derek Wells, Mr. Kimler?
I'll go get Wills. Yes.
Good morning, sir. Are you Derek Wells? And this is cause numbers 26 DCCR 0216 and 0529. Mr. Wells is charged with obstruction or retaliation as well as driving while intoxicated, third or more. And what is the announcement?
Further state, huh?
My understanding is that there is a misdemeanor DWI that is unfiled, is what,
I don't know if it's a misdemeanor, maybe a felony.
that's what Mr. Kimler's representing to me. He just told me that about 5 minutes ago. I'm not sure. But if that's the case, I certainly am not opposed to a reset so that we can run that down.
I've represented that to Mr. Cole and based upon what Mr. Wells informed me, so you have.
What's the offense date?
Yes.
What's the new offense date of the new DWI?
When did you get arrested on the latest DWI?
Exactly.
Well, be as best you can, what month?
I want to say 4 or 5 months after that one over there toward today.
This county, is that right?
Yes, ma'am.
So evidently 4 or 5 months after the one he's indicted on, he was arrested on another one in Jefferson County. And they want to try to confirm that before.
I'm
they
happy to
send-
confirm, Judge.
Are you still driving, Mr. Wells?
No,
Okay, I'm going to make it today a condition of your bond in the 2 cases that I have that you are not allowed to drive any vehicle, period, ever.
That was unusually direct. The judge just added a bond condition prohibiting him from driving entirely. Why? Because being arrested for a similar offense while already out on bond is one of the fastest ways to lose judicial trust. Judges take repeat behavior very seriously. It's one thing to make a mistake. It's another to repeat it while under court supervision.
The fact that you were on bond for one and got arrested for another gives me a whole lot of concern. So, Mr. Coleman will have some time and see where that is in the process. If it's waiting on some kind of, labs or things, we'll get that worked out. We'll reset a normal reset. Stay in touch with Mr. Kimler. He'll let you know when you need to be back. All right, you're free to go.
Thanks, Judge.
That's it.
Okay.
See, Mr. Lewis, you've got Devontre Johnson. I reset it.
It's okay.
Yeah, that's the MTRP that I reset. Morning.
Judge.
Good morning. Are you Devontre Johnson?
Yes, ma'am.
And this is 25 DCCR 0438. Mr. Johnson is charged with failure to comply with sex offender registration requirements. Mr. Lewis, what is the announcement?
Judge, I think we have a possible resolution with, I've talked to Ms. French this morning. I'm asking if we can have this case reset for next week, for next Monday. So I can meet with Mr. Johnson to thoroughly go over the potential.
Sure. Any issues with
consequences
a
of that.
1 week reset?
I have a vacation letter for next week. I won't be here, but someone will, they could.
You've already made your offer
I
and
have.
it's all that's done.
I have.
Okay, so we'll just do a 1 week reset. Obviously, if he wants to take that, we can get that taken care of. If for some reason not, then we'll get it set on the top docket and do a rejection. All right, thank you. You're free to go. We'll see you next Monday.
Thank you, Mr. Lewis.
Crystal Robinson, Mr. Lewis. Good morning, ma'am.
Good morning.
Are you Crystal Robinson?
Yes, ma'am.
And this is 25 DCCR 1869. Ms. Robinson is charged with deadly conduct, discharging a firearm, and what is the announcement?
Judge, there was some surveillance footage that's available in this case that I need to look at with her. When I talked to Ms. Robinson about it, she had some questions about that footage.
Okay,
So I need to talk, just review it with her more.
all right, so Ms. Robinson, I'm gonna reset your case, a normal reset, which is about 30 days. You need to make an appointment early, go see Mr. Lewis. Don't wait till the last minute. But right before court, call, make an appointment, go over all of that, look at what he's got, and we'll get an announcement at the next court date. All right, you're free to go. Simranjeet Singh. Good morning, you're Simranjeet Singh,
Yes, ma'am.
and this is 25 DCCR 1870. Mr. Singh is charged with theft of property, and what is the announcement?
Judge, I've talked with Mr. Nichols here, with the state. We've got an offer on this case. I think that will resolve it, but there is an immigration issue. So we can have, just a little time for him to confer with immigration attorney before we agree to that and finalize it.
So I'll do a normal reset. Mr. Singh, you need to make sure, make an appointment, visit with whoever you're going to with regard to any immigration issues before that next court date, okay? All right, we'll see you back then. You're free to go. Mr. Parker, you've got Maria Lopez or Marie Lopez. Morning.
Morning, Judge. And I need to make ask you to make a correction on the plea papers.
Okay. Good morning. Are you Marie Lopez?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Sure. On the,
Hold on just a second. Let me get it. That's the correct.
our recommendation, it should be 2/4 because she's not eligible for deferred. 2 years probated for 4.
Okay. Any issue with me making that modification on this? All right, Ms. Lopez, in cause number 24, DCCR 0886, you're charged with the state jail felony offense of driving while intoxicated with a child passenger from May 19th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes.
And so also you guys signed those post-conviction waivers at the bottom of the second page. Because there's not an agreement, I'm going to mark those out as well because she's not waiving that right to appeal.
Pay close attention here because this is different from the earlier case. This defendant isn't accepting a negotiated deal with prosecutors. She's entering what's called an open plea, which means she's putting her future entirely in the judge's hands. That can be a huge risk or a strategic move if the defense believes the judge will be more lenient. Either way, this is one of the biggest acts of trust a defendant can make inside a courtroom.
So it looks like there's not an agreement in your case. You're just pleading open to the court, which means you will have some rights to appeal depending on what happens. Do you understand? Do you also understand, if you're not a US citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And it looks like you and through your attorney will be requesting that I place you on probation, and that the state is asking for a 20-month state jail sentence. Is that your understanding? And what'll happen is we'll come back, the probation department will do a pre-sentence report. I'll get more information about you and your case. Then anything that you think is important for me to know, get that information between now and then to Mr. Parker, and he'll present it to me on your behalf when we come back, okay? All right, so I'm going to state tenders number one.
No objection.
It's admitted. Is there any evidence that Ms. Lopez is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing, like I said, so we can get that report done. And then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to the probation officer that's sitting at that desk right behind you, and she'll get that process started. All right? All right, we'll see you back at sentencing.
Okay.
Jorge Quezada.
Courtrooms may seem repetitive on the surface, but every case is its own high-stakes story. One defendant accepts probation, another rejects a plea deal, and someone else places their future entirely in a judge's hands. Tiny decisions made in minutes can change years of someone's life. Which moment surprised you the most?